Let's talk about other contracts now. First of all, a lease agreement between the lessor and the lessee. It's not an ownership issue. What it is the right to occupy more than anything else. And there are several kinds of leases that we deal with. The gross lease is a real common type of lease found in like apartments where a tenant is renting at a rental fee and the landlord is paying all of the operating expenses. A net lease, on the other hand, is more like in a commercial property where not only is the tenant paying a rent fee or a lease fee, but also sharing in the payment of all the operating expenses as well. Remember that leases, by and large, are like any other contract, that leases can be assigned unless there's something within the lease that will prohibit it from being assigned. And anytime that a person wants to assign their lease to somebody else, what they're basically doing is giving up everything that they have remaining in that lease to somebody else. Now, that's different from a sublease. In a sublease, I'm giving up less than everything I have remaining in the lease. I'll give you a good example. If I have a 3-bedroom apartment and I want to rent out one of my bedrooms to somebody else, that's a sublease. The different types of leases that we deal with, the tenancy for years, to me, that is a true lease and is quite binding. In other words, it cannot be arbitrarily terminated. It has a beginning date, it has an ending date, and it's in writing. Very, very, very binding. The tenancy at will, however, is missing one of those components. The tenancy at will, a good example might be a month-to-month renter. And that is to say it has a beginning date, but no ending date. Now, on a month-to-month tenancy, it's going to require at least a 15-day notice, a minimum 15-day notice to be able to terminate that lease. If it's a week-to-week renter, 7-day notice. A tenancy at sufferance is simply a holdover, somebody that doesn't have an agreement at all. Somebody that had a lease agreement, you look up and they're still there. Now, termination for them can be immediate. You still have to go through a legal process, though, to get there. Remember that the statute of fraud says that certain contracts have to be in writing to be enforceable. Remember that a lease for more than 1 year has to be in writing to be enforceable. And it also has to be executed with all the formalities of any other conveyance instrument. That is, it's got to be signed by the lessor, that is the giver of the lease, the owner, the landlord. And it's also got to have 2 witnesses on it. Now, the reason that we get the tenant or the lessee to sign a lease is to obligate them to payments. That does not transfer the interest. The lease also has to contain the legal description and all types of other things as well. The Florida Residential Landlord-Tenant Act is going to be important as well. And what we've got to do right now is separate out the real estate broker from the landlord. The landlord can do things that the broker cannot do. And let me give an example. To begin with, a landlord can put security deposits in an interest-bearing account or non-interest-bearing account. If they put it in an interest-bearing account, then they must pay their tenant either 5% interest or 75% of what was actually collected. So that's a little different than what brokers can do. But more importantly, landlords can commingle deposits. And what I mean by that is that they can take security deposits and put in their personal checking account. If that happens to be the case, then what the landlord has to do, first they're going to owe their tenant 5% interest for the use of their money. And secondly, they're going to have to post a surety bond with the clerk of courts in the amount of the deposit. Now, that surety bond is simply an insurance policy that will pay for that in case that landlord spends that money. So they can commingle, but there's some caveats to it as well. Also, as far as the security deposits are concerned, at the end of the lease, if the landlord intends to retain any of the deposit for damages, they've got to notify the tenant at the termination of the lease by certified mail within 30 days of their intention of retaining the deposit with a list of why they're retaining it. So the Landlord-Tenant Act really kind of outlines what the landlord and tenant's rights are as far as their leases are concerned. Another type of contract that we deal with is called an option contract. The option contract is between the optionee and the optionor. The optionor is the giver. That is the potential seller. The optionee is the buyer. This is a unilateral contract, and that is to say that only one party is promising to do something, and that is the potential seller. The seller obligates them to sell. The potential buyer, the optionee, has a window to be able to look and say whether they want to buy or not. And I've got in your text a number of option contracts and exercise of that option contract. Also, I've got a little comment about lease options. I think we need to be careful about lease options, because what we don't want to do is to start practicing law in these situations. Let an attorney do it. That's all I have for the other contracts. So what I'd like to do right now is to go ahead and review with you this section, those areas that I know that's going to be important to you. An assignment of lease gives up everything remaining, whereas a sublease only gives up a portion. A tenancy at will could be a month-to-month renter and requires at least a 15-day notice for eviction. The statute of fraud requires leases for more than 1 year to be in writing to be enforceable. Landlords can commingle deposits with personal money, but must pay the tenant 5% interest and post a surety bond with the clerk of courts in the amount of the deposit. And that's all I have for that chapter.